Hi, I'm Tina. I've spent the last 13 years nearly working in wills, probate and estate administration, and I also do powers of attorney and advanced healthcare medical directives. I'm sure you wouldn't be surprised to learn that a lot of people have asked me, why should I make a will? I don't have anything to leave. I'm not rich. I haven't got estate, whatever that means. Well, if you don't have a will, then what will happen to everything that you own is that it will go into an intestacy, and I'm going to tell you exactly what that means. You should note, if you are in a married couple or a civil partnership and your estate or stuff is worth over £270,000, then it will end up getting split between you and any children you might have, and that has a lot of implications for inheritance tax, but I'll be doing that in a different video. This video is going to assume that the amount of stuff that you're leaving behind does not mean that you're going to be paying any inheritance tax. The first thing we need to clear up is what exactly is your estate. Your estate is literally everything that you might leave behind. So if you own a home, it includes your home, jewellery, books, records, CDs, your computer, television, clothes, everything that you might leave behind, no matter how small or how big. The exception to intestacy comes if you own something jointly with someone else. So if you own your house under a joint tenancy, then that will pass automatically to the co-owner. The same with joint bank accounts and items like that. However, if you own your home as a tenant in common, then that will mean that your bit of your home will pass under intestacy. So you do need to make sure you know how you own your own home. In the first instance, the person who will receive your entire estate is your spouse or civil partner. So that means your husband, wife or civil partner. There's no such thing as a common law husband or wife in English and Welsh law. If you aren't married or in a civil partnership, your partner has no legal rights. It's your husband, wife or civil partner who will receive everything in the first place. Your spouse or civil partner has passed away before you do. Second in line is or are all of your children. This includes biological or adopted, but doesn't include stepchildren. They will receive absolutely everything in equal shares. If you have no children surviving you, but you do have grandchildren, then they would be the next in line to receive everything from your estate. Again, if you have no grandchildren surviving you, the line would then pass down to great-grandchildren, and it will keep going until you run out of any descendants. They're known as lineal descendants. They have to be in your direct bloodline. Just because you may not have any descendants, that doesn't mean intestacy runs out. We now go to look at what surviving blood relatives you might have. In the first instance, it would go to any and all of your surviving parents. If you don't have any, then it would go up again to all of your surviving grandparents, until we run out of a line of inheritance going up. So you have no descendants and everyone above you has already passed away. Now we start going out sideways. At this point we're looking at your siblings. There is a differentiation made here. It is only your full blood siblings. So any half siblings you may have are excluded at this point, and it will be all of your full siblings who will be sharing your estate. If you don't have any full siblings, it will then start going down their line of descendants. So the next layer would be your nephews, nieces or nibblings. And again, if you have none of those, it would go down to their children. And it would keep going until you run out of anyone down that line. Once you've run out of the lines of your full siblings, it is at that point that half siblings would come in. And if your half siblings haven't survived you, then it will keep going on down their lines until you run out of surviving people to inherit. Now we move on to your full blood aunts, uncles and piblings. All of them, all at once. Again, if you don't have any of them, then it will just keep going down their lines, as it has done with all of the previous ones. So this means your cousins, all of them, at the same time. And I think you can see at this point we're maybe getting into rather large groups that need to be looked for. You have absolutely no surviving blood relatives at all. Well, in that case, it is the government that will take your entire estate. However, if you live in Cornwall, it's the Duchy of Cornwall that will take the estate. If you live in the Duchy of Lancaster, then they get everything from your estate. Everyone I am listing not only inherits everything from your estate, they also have the responsibility of administrating everything. And that's everything from the date you die. Families are complicated, and increasingly they're taking forms that don't fit into the way the law has families defined. Children in families often have different parents to each other, and half-siblings are so common these days, but they aren't recognised in law as the same as full siblings. The same with relationships that I don't fit the role that the law defines relationships as. Grief is a traumatic experience. In my work as a probate practitioner, I saw so many arguments and so much grief pouring out of people, and decisions being made that they may not have done, and discussions being had that may not have happened if they just had a little bit of guidance from the person who'd passed away. It comes from the worry that they really want to do what would be right by the person who's passed away, and they're just fretting that they don't know what it is and they're going to get it wrong. A will really does take care of all of that, and it's the only way to make sure that all of your stuff, your estate, is passed the way you want it, and people know who you wanted to take responsibility for that. The hippie in me likes to call a will the hug you leave behind, and the legal person in me knows that a will give you peace of mind to know that you have planned for what happened, and that you know who's going to take care of everything after you die. And once you've written a will, you can stop thinking about it, you can stop worrying, and you can just get on with living your life. Plan for the future, but live in the now. And that's why you should make a will.